save the United States and this honorable court.
Good afternoon, Ms. Kubanda and Mr. Durant. I'm Judge Dennis. I'm sitting with Judge Elrod and Judge Duncan. We'll be your panel this afternoon. So without further ado, we'll begin. Ms. Banda, you may begin.
Thank you. And may it please the court, Rachel Kubanda on behalf of the petitioner. Your honors, we are here today because the petitioner, Mr. Josue Cardona-Franco, seeks this court's review of a final decision issued by the Board of Immigration Appeals entered on September 20th, 2019. In this decision, the board dismissed petitioner's appeal from a March 22nd, 2019 decision of an immigration judge denying his applications for asylum and withholding of removal. On October 22nd, 2019, petitioner timely filed his petition for review with this court, which is now the subject of this appeal. And for clarity, I will be referring to the Board of Immigration Appeals as either the board or BIA. Briefly, your honors, if I may address the background facts. On November 7th, 2015, Mr. Cardona entered the United States with his twin brother from El Salvador as a minor. He was 17 years old. Mr. Cardona is an El Salvador native, and his parents are pastors of a small church in San Salvador called Prince of Peace. Mr. Cardona identifies as an evangelical Christian. During the months before he came to the United States, Mr. Cardona and his twin brother, Samuel, endured repeated beatings as well as death threats from gang members who were part of Barrio 18 and MS-13 on account of his religious beliefs. And to just highlight those, there are 5 specific instances that the petitioner identifies. One of them was a beating at school due to his religious beliefs on April 17th, 2015. Another was on June 16th, 2015. He received death threats from classmates who had orders to kill him. On June 23rd, 2015, he and his brother received a beating on the bus and again was threatened for his religious practice. They said, let's see if you keep preaching, Christians. On July 18th, 2015, he received death threats with guns outside of his church. And ultimately, on August 19th, 2015, he received an ultimatum that he had to join the gang or would be killed. Due to these events, he and his brother felt that they had no choice but to leave El Salvador. Upon entering the United States, Mr. Cardona and his brother were eventually connected to a pro bono organization called KIND, Kids in Need of Defense, in which they were connected with legal counsel. They completed and submitted nearly identical applications for asylum. Petitioner's application was denied, and an immigration judge assumed jurisdiction over his application. On March 22nd, 2019, and after a hearing on the petitioner's asylum application, the immigration judge entered its decision. On October 22nd, 2019, petitioner filed a petition for review with this court. Your honors, multiple errors in this case justify reversal and remand from the Board of Immigration for further consideration. To begin, the board erred in refusing to take administrative notice of the agency decision that it granted asylum to his twin brother, Samuel. The board is entitled to take judicial review of official documents issued by other courts and by itself. Administrative notice, which is official notice taken by administrative agencies, is very similar to judicial notice, but is broader in scope. The board has authority to take administrative notice from Title 8 CFR Section 1003.1, subsections D3, 9, Romanet 4. These are the federal regulations that lay out the, quote, organization, jurisdiction, and powers of the Board of Immigration Appeals. This specific section provides that the board may take administrative notice of commonly known facts, such as, and it cites as number 2, the contents of official documents outside of the record. Courts have held that the scope of notice is broader in administrative proceedings than in trials, and that is from Castillo Viagra versus INS 972 F2D 1017, 9th Circuit, 1990.
Counsel, I'm a little bit confused by this point. It was already sent to the BIA. It's already in our record. What is it? What happened? What's the situation with the judicial notice or are you seeking us to make the BIA pay more attention? I don't understand what relief you seek vis-a-vis this claim.
Yes, Justice. We are asking for the BIA to take administrative notice. The fact that these twin brothers' applications were essentially identical, relaying the same events and supporting evidence, is determinative and can help the petitioner in his credibility.
But the BIA already has that. So it's noticing it. It just may not be doing something with it, right?
Well, we are asking this court to remand back to the BIA for further proceedings. We did not learn of the order until after our appeal to the BIA and after the merits hearings before.
So was it not already sent to the BIA? I thought it was already sent to the BIA. So I don't understand that we need to tell them to read things they already have. Maybe it wasn't already sent, but that's what I thought.
We had filed a motion to remand with the BIA and that was dismissed. And so because we cannot get in new evidence, we are just asking the court to take judicial notice of the fact that this agency decision exists and that the facts are replete with facts that the brothers both face the same abuse and violence in El Salvador.
But we don't have to take judicial notice of things that are already that were already part of the record because they were with the BIA, though. It was already sent to the BIA. So I'm happy to consider it, but I don't think we need to take any formal notice of it.
Okay.
I mean, Ms. Kubanda, do you agree with Judge Elrod? What she's saying is that the fact that the brother got asylum was before the BIA knew about that. Is that correct?
The BIA, the panel that we were in front of from the BIA was not aware of that until we filed our motion to remand, asking for them to consider new evidence.
You filed your motion to remand with the BIA, though, right?
That's right. That's right.
So then at that point, the BIA became aware of it and could choose to remand to the IJ or not, right?
Correct. And they did not find that that was probative.
Well, did the BIA, correct me if I'm wrong, the procedure is a little complicated. Did they find that the motion was not timely?
That's right. And we filed a motion to reconsider, which was also denied. So we proceeded with this petition for review. And because the agency decision.
Okay. I get that. So are we reviewing the BIA's denial of a motion to reconsider the untimely motion to remand? Is that what we're doing? Because like Judge Elrod, I didn't really understand how we were being asked to deal with the brother's asylum. Like, what was the procedural posture?
We want this court to take into consideration the brother's asylum grant that allows him to stay in the United States. We think that is massively helpful for the petitioner's case, and that was not part of the record. And we're not asking this court to consider the motion to remand, but we are asking this court to take into consideration the agency decision and to also instruct on remand the BIA to also likewise taken as administrative notice the asylum decision for his brother.
Well, we have to have a decision to something to remand, some determination. If you're wanting us to remand to the BIA, which is what I think you want, right? You don't want us to determine that he's entitled to asylum. We can't do that. You want us to remand to the BIA for them to look at this again.
Yes.
What is the vehicle that you want us to remand? What is it? A motion for reconsideration? Is it a motion to reopen? Is it a denial of what is the document that we are reviewing here as the appellate court to be remanded?
We are looking at the final decision issued by the Board of Immigration that was entered on September 20th, 2019. And we want this court to vacate that decision and remand these proceedings back to the Board of Immigration so that we can essentially have these issues reheard by the Board of Immigration.
Right, but you filed, correct me if I'm wrong, you filed a motion to reconsider with the BIA because the BIA said, no, we're not going to do that, right? We're not going to remand. And the BIA said, the reason we're not going to remand is that your motion was untimely, right?
That's right. And it was untimely because we didn't know we had to pay a fee. It was physically got there, but it was rejected.
I get that, but when an agency that we're reviewing says, look, we're not going to do it for these reasons, then we have to, as you know, we have to say, well, that you abused your discretion, you know, you made a legal error. Like what Judge Elrod is saying is, I think, is, well, on what basis do you want us to do that? I mean, we have to have an error to correct, right?
It's an abuse of discretion, Your Honor.
Well, in what way?
Because it wasn't part of the record. And so we need the court to consider this critical piece, this critical document that could assist the petitioner in his case.
Okay, all right. So that's the argument with respect to the brother's asylum. Did you have some other points? I mean, you don't have much time left, but you certainly have some other points if you want to talk about those. Or...
Yes, Your Honor. The
Can
board.
I ask you real quick? I'm so sorry. The final decision in 2019, that's the motion denying the motion to reconsider. Because I'm not sure we have jurisdiction to review a motion to reconsider. Maybe we do. I was going to ask Mr. Durant that as well, because whether we don't have jurisdiction on some discretionary determinations, even to review them. So do you have any comment on that?
Your Honor, I think we tried to bring up the issue. It was denied. The motion to reconsider is not before you, but we are asking that the final decision entered by the Board of Immigration, which doesn't, I believe, address the asylum grant to the brother, these proceedings need to be remanded back to them so that they can take that into consideration, as it's not part of the record. Your Honor,
the main reason you seek them to remand is that the district, the IJ made credibility determinations that were wrong.
Yes, Your Honor. The board erred in the petitioner's due process rights, acting as an impartial and neutral arbiter on petitioner's claim. And for example, the immigration judge committed clear error by relying on irrelevant facts and evidence that do not exist in the record at all. The BIA improperly asked the respondent to state how many books were in the Bible and to name the first 5 books of the Bible. And these facts are irrelevant, and no reasonable adjudicator should rely upon these types of trivia questions to determine.
I read your brief and I thought it was well stated. I have to tell you, and it was a little unusual to read about a question like that. And I'll certainly want to hear from the government about it. But the IJ has to determine credibility. Part of the credibility was, I'm a preacher, I'm an evangelist, right? Now the IJ, I think, has to probe whether the petitioner is being truthful. So it sounds odd, and I'll grant you that. But isn't it plausible that the IJ said, okay, well, you say that you're an evangelist, but I don't believe your story, so I've got to probe it. Is that not within bounds for an IJ to do?
Your Honor, it's not proper for the immigration judge to assess Mr. Cardona's religious beliefs and commitments based on his knowledge or lack thereof of the first 5 books of the Bible. There's a case called Ting Ting Yi versus Sessions 695 F Apex 785, which is a 5th Circuit case from 2017. And in that case, an immigration judge questioned the petitioner's religious commitment because she couldn't recall specific details of her baptism. And she had only been connected with that religious group for 6 weeks. And how, if that was such a significant transformative part of her personal life, why could she not recall specific details? And the Fifth Circuit held that these types of judgments are wholly unsupported by the evidence and involve speculation wholly outside the proper purview of the immigration judge. And so in the same regard here,
I'm glad you cited a case. Is that case cited in your brief?
it is not, no, Your Honor.
Oh,
I don't
okay.
believe it is.
All right. Ting Ting Yi versus Sessions. Okay. Well, I'm
I was
interested.
on that panel, wasn't I?
I believe you were. Yes.
But you need to, did you provide that to Mr. Durant?
I'm not sure if I cited it in my brief.
Well,
I may
that's
not.
not, you can't, okay, well, that's up to Judge Dennis, but I would encourage you that you be forthcoming with opposing counsel about any cases you intend to rely on.
Yes, Your Honor. Apologies. I just wanted to add that I thought that case was helpful only because the court basically found that
And are
these
you?
are very. May I finish?
You're out of time, Ms. Kubanda.
Okay, thank you.
We'll have 5 minutes on rebuttal.
Thank you.
Mr. Durant?
Good evening, Edward Durant for the United States. Substantial evidence supports the agency's adverse credibility determination. This case relies on credibility. The merits of petitioner's asylum application, whether or not he was persecuted or not, or whether or not he's entitled to asylum, the board did not make that determination. So the only thing they rested the decision on is credibility. And the immigration judge gave several salient reasons for not believing petitioner. And again, now he can rely on anything he wants. Anything, it doesn't have to have anything to do with the persecution either. The first thing that the judge talked about was Mr. Cardona's arrest in the United States for brandishing a weapon. The judge gave several reasons why he didn't believe petitioner. First is that he said he was non-responsive. Well, that's true. He asked him, why did you have a toy gun? And there was no response. He was also inconsistent in several regards. He was asked point blank, why were you arrested? He said, I don't know. And then he admitted people accused him, and this is all in respondent's brief. These people accused him of waving a gun at them. And then he was asked, did you wave a gun? And he said, no. And then later he says, oh yeah, I may have brought it up and held it and then showed it to them. His answers in addition were nonsensical. The judge was asking him about why he was arrested for brandishing what was a BB gun. And he's talking about getting tacos, and that gave this other nonsensical reason that he found it in a garbage can and then put it under his car because that's where he put his other toys.
Was
Under
he
the
having
seat of
trouble
the car.
understanding what was going on?
There's no indication in the record or in petitioner's brief that I'm aware of that he did not understand his interpreter. In fact, the judge and the petitioner makes a due process argument in her brief, but the immigration judge was always asking petitioner if he understood the interpreter, and that's also in respondent's brief. So again, yes, ma'am. Okay,
so you believe that there are these incorrect statements, these nonsensical statements made. The judge also gave a number of other points, though, some of which may not be appropriate. And we just had a case, and I'm trying to think, our court just had a case where there were 5 or 6 reasons and 3 or 4 of them were not appropriate.
I think it's Singh, Your Honor.
Thank
I think
you.
it's Singh. And that's the reason.
So once it gets to a certain amount that are not appropriate, we have to send it back to remand to see if that makes a decision. Why isn't that the situation here?
Well, I will argue that these findings were strong. Now, the judge did say he was reminded that it was a BB gun. That is not true. But in that finding, he gave 4 or 5 reasons why he didn't believe petitioner. And what petitioner was doing was minimizing the entire time. And there is case law here that there's no reasonable possibility that the agency would find him credible, but for any errors that the court sees. The smoking gun in the room is petitioner's letter. Petitioner said he was beaten. He gave specific details. He was beaten on 17 April 2015. I believe that was the date. He knew He knew the time, the date, what happened to him. He and his brother were really pounded. And then he files a police report. Not only does the police report not mention the beating, and this is why they went, it gives a different reason why they were attacked. Petitioner said it was due to his being evangelizing. And the police report says it was because they were from a different neighborhood. It had nothing to do with the fact that with the heart of his asylum claim that he's being persecuted because he's evangelizing. In addition, the letter from his father, who wrote his letter knowing that his son was applying for asylum, never mentions one beating at all. And he never mentions the religious animus. And it's how does Petitioner sustain that? How can he claim that he's credible on those facts? In addition, the immigration judge found that Petitioner was able to give specific details about every attack that allegedly happened in El Salvador. He knew dates, he often knew times, he knew the number, he knew when it happened. 6 incidents, including his father, who was allegedly harassed after he left. But juxtapose it to when the judge asked him a simple question, when did you go to Liberty High School? He couldn't even give an answer. It's implausible, given his laser-like testimony on this other stuff. So it leads a fact finder to believe that this story is made up or simply rehearsed. In addition, he didn't know when his sister Clara came over, even though he knew all these other dates about himself. And he said that she came over in 2015 after an event in 2015, August of 2015. His sister Carla, who spoke after him, said she believes she came over in 2014. So if Clara came here in 2014, Petitioner's testimony regarding one of those events is a total fabrication. And when you get to Carla, his sister, she can't explain why her father's letter doesn't have all these salient details. And she allegedly has these 3 letters that they received, yet she forgot to bring it. She forgot to bring these letters to the court. It's just not plausible. And so even if the adverse credibility determination was imperfect, it doesn't mean that this court is compelled to reverse. And certainly there's no reasonable possibility that he would be found credible if the court sent it back. Now, with respect to Petitioner's due process arguments respecting the judge was fair. I outlined this in our brief. He gave him breaks. He let him. Yes, ma'am. Is there someone who wants to ask a question?
No.
I may have been clearing my throat. I'm sorry. I've been talking.
Very good. I'm sorry, Your Honor.
Let me just, if I can get you to go to another subject that we talked about with Ms. Kubanda, the asylum determination for his brother. What is your view of what sort of the vehicle that issue is presented to us in this petition? Because I'm a little unclear on what we're sort of supposed to decide with respect to that. I mean, the petitioner says this is very important evidence, and we're being asked to do something with respect to what's the government's view of how that issue is presented to us, and how do you think we should resolve it?
Well, first of all, I can tell you the procedural history, Your Honor, but I would say it's irrelevant. He's not derivative of his brother. These 2 asylum applications stand on their own. And the government cited case law supporting that proposition. And I don't know what was said in Petitioner's brother's case. I don't know the level of scrutiny he received. The petitioner keeps saying that it's identical, but the only thing we have is a piece of paper.
Sure,
So
that sort of goes to the merits of it. I want to understand how it is how is it before us? What are we being asked to do in the government's view with respect to this brother's asylum determination?
It's government's understanding that, well, first, the petitioner submitted it on appeal after the first decision, and the board said, "Listen, we're we're an appellate body, and you didn't tell us why you couldn't get it, and 3, I don't think it would make a difference." I think that's what they said. Then they made a motion to reconsider, and it was untimely. The court said, "And you haven't shown an error in law and fact because the motion to reconsider doesn't address the adverse credibility determination at all." And then the court said it wouldn't make a difference in any event because it really has nothing to do with the adverse credibility determination. Who cares if he got his asylum application? Perhaps he received less scrutiny, but has nothing to do with all the rampant errors in Petitioner's case.
Now, Judge Elrod also asked about, and I'm asking her questions for her. I'm sorry. I was interested in the answer. If we're being asked to review the denial of a motion to reconsider on this point, do we have jurisdiction?
In our brief, I said, I believe the court has jurisdiction.
Okay.
Under, like, you review it for abuse of discretion. And what I found, and that's the case law, is the court has jurisdiction to review a motion to reconsider for an abuse of discretion, whether or not the agency acted outside its considerable discretion. And it gave 3 reasons, assuming the court thinks it has jurisdiction. The board gave 3 reasonable reasons why it denied the motion. First, it was late. Second, it didn't specify an error in law and fact of any relevance because it didn't address the credibility determination. And finally, the court said it wouldn't make any difference. They cite Cohol. So they give 3 reasons, very persuasive ones.
Okay, I get it. So the government's position, I think, maybe not definitively, but appears to be that we review that for abuse. We review those reasons for abuse of discretion.
Based on a denial of a motion to reconsider is denied for abuse of discretion based on the research that I did. And now, so I've already talked about due process, how it was fair. He never limited his testimony. In fact, he let him say everything he wanted. He didn't cut out any of the evidence he wanted to submit. In fact, Petitioner was able to submit even a baptismal certificate after the fact. The judge may have arguably been stern, but certainly wasn't unfair, and no bias there. So the due process arguments are nothing more than a red herring. The judge was more than willing. Moved around when Petitioner's sister could testify. She was having a baby. He let Petitioner's expert testify via Zoom or telephonically. He even accepted a document late. And what the court could note is to date, we don't have these alleged letters from the threatening letters that Petitioner's sister talked about. And one thing is we don't have any report card from Liberty High School where he said he went. He got all this other evidence, and it's just a glaring error in the record. It's just right there. So in closing, this case rests on credibility. Substantial evidence supports the agency's determination. Certainly, there's no compelling reason to overturn it, even if it isn't perfect. There's no reasonable possibility that the agency would find this person credible, given everything on the record. Thank you very much.
Thank you, sir.
That's all I have, unless the court has any questions.
Apparently not. Ms. Kubanda, you have 5 minutes on the vote.
Thank you, Your Honor. Your Honor, the misdemeanor charge was ultimately dismissed. That's a separate proceeding, and it's not relevant to the merits of this appeal. As far as the mention of the toy gun and how the petitioner was allegedly being evasive and not answering questions, while it's true that the petitioner referred to the weapon as a toy gun, no one, including the immigration judge, ever reminded him at any point that he should be using BB gun rather than toy gun. In fact, the immigration judge herself, as well as government's counsel, only used the terms toy gun and toy pistol in describing the weapon. And that's at record sites 185, 1186, 1188, and 1294. The mentions of the police report.
Sorry, I was muted. I made the classic Zoom mistake of trying to talk to myself. He was testifying in Spanish, no doubt, right? With a translator?
That's right, Your Honor.
Is there any issue here about what was he actually saying in Spanish with respect to toy gun, BB gun? Or is that just...
That I was not there, but foreseeably, that could definitely be an issue. There were issues during the trial because it seemed that the immigration judge was confusing the sisters at one point, Carla versus Clara. And so there were, issues with him sort of understanding that. And there's always a time delay because they had to translate and wait for the translator to be.
Okay.
The petitioner, as far as the police report, the petitioner did not draft that report, but what it does is it helped corroborates his testimony that he was attacked on that day, that attack did occur, and that helps, establish the fact that he was physically beaten on a certain day, and they went and reported that to the police. Now, did the police report include, commentary about religious persecution? No, but there's a police report that exists that corroborates his testimony that he was physically beaten on a certain day. And as far as issues and inconsistencies in his timeline, there is case law that says that mistakes in minor issues are not dispositive of a case. For example, there's a case that holds that adverse decision principally relying on utterly trivial discrepancies in dates is remanded, and that is at Ally June versus Holders 751 F3D 1088 9th Circuit 2014. There's another case, Cadia versus Gonzalez, which is a 7th Circuit case, which faults the immigration judge for failing to distinguish between material lies on one hand and innocent mistakes, trivial inconsistencies, and harmless exaggerations on the other hand. So the fact that the petitioner couldn't remember the last day that he attended high school or the certain time frame when one of his sisters came to the United States should not be dispositive of his asylum application and his case. And with that, Your Honor, unless you have any questions, that's all I wanted to address.
Thank you.
Thank you.
Okay, well, thank you, Ms. Kubanda. Case will be submitted and taken under advisement. And this panel will adjourn without date.
Thank you very much.
Thank you very much.
Did we get telephone numbers to call in, or?
I haven't got one.